The CPI report, Child Protection in Iowa, is brought to you by Vocal Victims of Child Abuse Laws. You can watch our program on Sunday afternoon at 1 o'clock, and again it's repeated on Wednesday evening at 9:30, all on Mediacom Cable Channel 15. You can email us at vocaliowa@mchsi.com. My number is 276-3956, and John's telephone number is 282-2672. With me at the controls is my co-host, and my name is Don Burgmaier. John?
You almost forgot your name, huh? Okay. We better bring up another mic here. And my name is John Harvey, and welcome to the CPI report. Yes, those numbers and that email address is for you to communicate with us about what you would like to see this program doing for you. We trust that the kind of information we're passing along will be of assistance to you and your family as you deal with the court system and as you deal with the Department of Human Services. We are not attorneys. We don't hold ourselves out to be attorneys. We certainly wouldn't want to be in a position of being, for someone pointing a finger at us and saying that we're practicing unauthorized practice of law. So we don't hold ourselves out to be attorneys, but we can give you hints legally because of your phone call and your expressed concern. Well, there's a number of things that are going to be happening in the next 100 days because the Iowa General Assembly is now in place. At that General Assembly, there are lobbyists and there are people who would like to contact the people's representatives down there, the House of Representatives and members of the Senate. Well, that can happen. In fact, one of the organizations with whom we've been dealing is called the Fully Informed Jury Association, and they're going to be at the General Assembly. They're going to have table and brochures and information about what is a fully informed juror. Well, we have been talking on this program that a fully informed juror is one who not only decides the facts of a case, but who are let in on the information regarding the law in a case. In my particular case, the jury was shut out from knowing anything about the law in the case. In fact, I held up a book called The Iowa Rules of Criminal Procedure, and I was chided by the judge for letting the jury know that there was such a thing as the Iowa Rules of Criminal Procedure, which the court had abandoned. They didn't think they had to follow the rules. They didn't think they had to abide by the rule of law. So the fully informed jury is one of those last stopgap protections that citizens have, and you'll be well rewarded if you would like to go to the Capitol on the 18th of January. Now, this program airs once before the 18th and once after the 18th. On the rerun, or the second run, you'll probably not get a chance to go to the Capitol because it's all over with at that point. So see if you can put that on your calendar for the 18th of January. And Don also has an announcement for another meeting that you may want to attend. One of them is my trial, and that is a hearing on appeal in my case. It'll be at 8:30 on the 4th of February in room 313. It's Judge Blink's court, and that's when will come to some resolution as to whether I indeed violated some kind of a criminal statute which interfered with official acts. I didn't know that I did, but apparently someone thinks that I did. Don?
What courthouse are you referring to?
This
John?
is to be the Polk County Courthouse
Okay.
at 5th and Mulberry. And Don, would you like to tell us a little bit about another hearing at the courthouse at 5th and Mulberry?
Yes, here's a guy that actually doesn't live in Polk County, but he lives on the eastern side of Iowa, Bettendorf. And he's going to have a hearing, as you can see on the top line, in the same courthouse, Polk County Courthouse, February 7th at 10 o'clock. And his issue come from, he wasn't actually arrested for about his refusal to take shots in the arm, I suppose, or wherever they was going to shoot him. But he has plenty of knowledge about how deadly shots can be, and a lot of people die just from the shots if you follow the information very close. Anyway, because he's outspoken, they came, I don't know if they came across the state of Iowa or where they originated from, but whoever went to his home and arrested him and threw him in the Polk County, I don't know if they actually physically threw him, but in the Polk County jail. And the charge is actually on harassment. But the documentation itself says that he wasn't causing them any trouble, but they just felt that he was harassing them, and of course he's just speaking out his knowledge. He's a chiropractor, and he studies up on medical issues and things, and has come to the conclusion that shots are either harmful or deadly to the person that receives them. And so he talks about that. Well, the government didn't like this, and even the federal government is the one that's involved, but I believe it's the county attorney is doing the prosecuting. It's Homeland Security that is trying to silence him from telling the public the truth. So, if anybody's interested in coming to that hearing, February 7th, next month at 10 o'clock at the Polk County Courthouse, room 107. And if somebody wants some more information on the subject, they can give us a call. Okay, John.
Okay, we've had a guest on our program a number of times, and he has just lost his status as being a guest. So we're going to have to somehow determine what to call somebody who has returned time after time with respect to what we should call this person now that he's no longer a guest. Maybe you already have a title for this associate correspondent. Don?
A title? Does Terrance need a title? He's been on here before. Oh, you, well, that's all right. We'll introduce him at this time, John.
How about a legal reform correspondent or consultant?
Okay, sounds good to me.
Sounds like a good one. Thank you guys for welcoming me on the show again. One of the things that I wanted to talk about, and you can feel free to join in on the conversation. One of the key issues today is the state of the judiciary message that was delivered by Chief Justice Lavarado January 12th, today, not 2005. He touched on several reasons why we should increase the judiciary's budget to $126 million, up over 118 million from last year. Now there are some valid reasons. I will give him some credit because in 2002 he basically sets forth what happened. There was 117 employees cut or laid off, eliminated 20% of the vacant positions and downgraded the positions of 79 supervisor employees. Now, with all that said and done, however, a couple of the things that I feel are missing. He goes on toward the end of the speech and goes on and talks about how people from Bosnia, Russia, and Moldova have traveled to Iowa to witness the justice system in Iowa and talked about how they regard this as a model of judicial independence and integrity. And then he also states the U.S. Chamber of Commerce ranks the judiciary in Iowa among the top 5 of all 50 states for creating a fair and reasonable litigation environment. Now, with all that said and done, he also says that our judiciary ranks high on quality, competence, partiality, and timeliness. So I think he's shooting himself in the foot by saying all this and then asking for more money. If that was the case, then you could operate on the same budget and still maintain the level of quality, competence, impartiality, and timeliness of dispositions. That is not the case, however, and I think we've talked about this a lot on the show. If you guys, the listening audience, has cared to watch. Couple other problems with his argument is that the U.S. Chamber of Commerce did not rank the judiciary in the top 5 using any sort of elaborate criteria. They basically went in and surveyed some people and ranked it among those people that participate in the survey, and that was for business business litigation. It had nothing to do with the citizens, which are responsible for most of the litigation and that are affected by most of the litigation in the court system. So I do think that that was a kind of he threw that in there kind of to throw people off, but you know, we do know the truth of that whole matter. But the problem, other problem I have with this, and maybe you could cite some of these statistics here, Don. As you can see, 2003. This is a report that was this was an attachment to the report, the state of the judiciary report. As you can see on these case filings for 2003, it shows the civil filings, criminal filings, juvenile filings, probate filing, small claims filings, simple misdemeanor filings, and temporary parental rights or termination of parental rights. Some of the other filings. Now the numbers for 2003 are supposed to be actual. The numbers for 2004 are projected as of the 10th of the month. As you can see, the numbers for 2004 and 2003 are almost identical. You know, some of them are higher, some of them are lower, but for the most part, they're about the same when you add them all up. So it just goes to show you there's about the same amount of cases being filed 2003 to 2004. Now, why would you want to increase the budget of something when something has not increased? Now, he goes all the way back to 2000 to show increase from 2000, but yet there's no justification being made from the year-to-year total on the caseload or the workload. And as you can see, simple misdemeanors, that also includes a lot of tickets and stuff, which are, for the most part, do not require a whole lot of work, especially when the people just send in their money and pay the fine or whatever. So, you know, to say, as he did in the speech, to say that they handle 1 million cases is kind of a overblown statement, considering that fact. You know, how many times, how long does it take you guys to think to file something away when somebody just sends money in? Do you think it takes a long time to do that, John?
No,
Or Don?
it shouldn't.
Yeah. So I mean, you know, we've got to talk facts and not exaggerations. And again, I'll go back to my old adage, which I was talking yesterday. When we uh, break a law, it's a crime, and we're convicted. However, if a judge breaks the law or wants to expand the language on something, it's called an interpretation. So I think Judge Lavarado needs to get his interpretations of the facts correct and present a more accurate picture and to the tax-paying citizens before he tries to justify $7 million increase in the budget. And then to also go back to what we were talking about last week, which was Judge Weaver. I can't remember what county Judge Weaver was out of. The same Judge Lavarado, who is so bent on raising $7.7 million for the judicial budget, he basically granted him a disability retirement to for his second OWI conviction, which is a big stretch, if you ask me. I've never heard of anybody being disabled because they were convicted, were second time around arrested for OWI. So why would you want to go ahead and spend money on a guy, give him disability retirement when he's only 51? If he lives to 90, at the judge's salary per year, it's almost $100,000 a year. Disabled retirement, I think they get a fraction of that. I may be incorrect. I may be not. Maybe I'm not correct, but I'm just guessing. I tried to get the actual figures from the court today, from the Supreme Court's office. But the fact remains, if you're going to spend money, you've got to spend it wisely to justify increasing everybody's taxes. This is not a wise expense to be giving this guy retirement at age 51, disability retirement from a judgeship for his second arrest for OWI. He should be kicked off the bench. If anybody out there was arrested for OWI twice and it would put them in a position where it jeopardized their job, it would also jeopardize your retirement. Here we have a situation where the judge feels free, Chief Judge, Iowa Supreme Court, feels free to just throw taxpayers' money away for his crony, Judge Weaver, for being arrested for a crime, and at the same time is asking for $7.7 more million. I think it's appalling, and it shows the lack of true leadership and integrity of our court system right now.
You mentioned calling the Supreme Court for facts. Did you get the information you were looking for, Terrance?
No, I got the runaround, which I wasn't surprised of, but I don't think that they would be forthcoming with that kind of information anyway. It tend to put them in a bad light. But, the bottom line is, no matter what this guy's getting paid, he shouldn't be getting paid. If he's fired, he should be out on his duff just like anybody else would be. They were arrested second time around for the same thing. Obviously the guy must have a drinking problem, because you don't get arrested twice for OWI within that short time frame, which he did, if he didn't. And there's no excuse. Couple other things I wanted to touch on. I don't know where you guys wanted to take this today, but some other thing I was going to talk about. I got an interesting article here from the folks I stay in communication with the matter of justice. This is a good article out of New York by Zachary Dowdy, staff writer. Court jesters, 2 legal reformers arrested after telling lawyer jokes. I think you'll find this interesting. This is what they try to do, the legal reformers. Harvey Cash and Carl Lazeria poked fun of lawyers while in line at First District Court in Hempstead yesterday. But court officers weren't laughing. Some are the jokes. Here are some of the jokes that got them in hot water. What do you say to a lawyer with an IQ of 50? What do you guys think the answer is?
Good morning, Judge.
Good morning, Your Honor. Here's another one. Why do they bury lawyers 100 feet in the ground?
To get rid of the stink?
Because deep down, they're good people. Now here's
Are you
another
sure
one.
100 feet is enough?
Now, what's the difference between a vulture and a lawyer?
I don't know. They both pick your pockets.
Okay, wingtips. Now, it says goes on to state not only does it talk about the jokes that they were telling, but it also states that the two men are founders of Americans for Legal Reform, a group of outspoken advocates push for greater access to courts for the public and to monitor how well courts serve the public. One tactic is driving a truck around the Huntington area emblazoned with the slogan, "Stop the lawyer disease." They said their rights to free speech were violated Monday. The line leading into First District Court in Hempstead Monday morning was long and frustrating, but it was the punchline in a lawyer joke that got two rabble-rousing comedians arrested. How do you tell when a lawyer is lying? Harvey Cash, 69 of Bethpage, New York, said to Carl Lazaria of Huntington.
You watch his lips, and if they're moving, he's lying.
There you go. He said his lips are moving, they said in unison, completing one of what may be 1,000 of standard lawyer jokes. So, I mean, this is a situation here. This is common. I think that a lot of people that are trying to reform the system, that are trying to bring this sort of information to the limelight, are in the same kind of situation.
What do you need if you see a lawyer buried up to his eyebrows in sand?
Nothing.
More sand. More sand.
And I really don't have the sort of disdain for lawyers. There's some good ones out there. There's some bad ones out there, just like with any profession. But I just think that that's appalling that they got arrested for telling those kind of jokes. The other thing I was going to talk about was and I'll give the floor back to you, was the court case that came out from the Supreme Court in the court case of U.S. versus Booker. And this is a report from the Associated Press, January 12th. Court sentencing system is wrongly applied. Washington, D.C., the Supreme Court ruled Tuesday that federal judges have been improperly adding time to criminal sentences, a decision that puts in doubt long-time sentencing rules. The court, on a 5-4 vote, said that its ruling last June that juries, not judges, should consider factors that can add years to defendants' prison sentences applies as well to the 17-year-old federal guideline system. The justices refused to backtrack from a 5-4 decision that struck down the state sentencing system because it gave judges too much leeway in sentencing. But the High Court stopped short of striking down the federal system. Justice Stephen Breyer said that the federal sentencing system is at least in part invalid because it forces judges to use the guidelines. About 64,000 people are sentenced in federal courts each year under a system that had been challenged as unconstitutional in a pair of cases at the Supreme Court. The divided ruling Wednesday took longer than expected. Justices had put the issue on a fast track, scheduling special arguments on the first day of their 9-month term in October. Most court watchers expected a ruling before the holidays. The federal guidelines are intended to make sure sentences do not vary widely from courtroom to courtroom. While juries consider guilt or innocence, judges make factual decisions that affect prison time, such as the amount of drugs involved in a crime, the number of victims in a fraud, or whether a defendant committed perjury during trial. The High Court's vote to require more jury participation was 5-4 and included the same odd right-left combination of justices as those who had held sway in June. Justices Antonio Scalia and Clarence Thomas are the court's most conservative members. Justices John Paul Stevens, David Souter, and Ruth Bader Ginsburg are the liberal wing. In the dissent, the 4 justices wrote, "History does not support a right to jury trial in respect to sentencing facts." So I guess they were in the dissenting part of the decision, which was rather long. I looked at the opinion. I was like, wow, 124 pages. Very long.
So when did that opinion come down?
That came down January 12th,
Okay.
which is this is going to be a very interesting decision. See how it's interesting how this is going to play out. The guy was sentenced under the provisions. He was authorized to be sentenced to 210 to 262 months, but after a sentencing hearing, the judge found additional facts by preponderance of evidence, and he made these findings, which he said gave him a longer sentence of 300 or 30 years instead of the 21-year 10-month sentence he could have been that could have been imposed on him. So yeah, this is a very, very, very interesting case because 64,000 people a year. Can you imagine? They got to go back 17 years. 17 times 64,000. It's just unbelievable. But I imagine the reason they didn't want to throw them out by altogether was because they probably would have a huge, huge backlog of cases. If you think they're busy now, they'd really be busy if people filed further appeals and habeas corpus actions or whatever to try to oust their or get their sentences overturned. I just thought that was very interesting. Oh, did you have any comments on that? I know you. I showed you. I think I showed you the opinion that they were talking about, the previous one anyway, the Apprende case that they were talking about.
Don?
Now I'm
There you
waiting
go.
on John to comment.
Okay.
Well, that's fine. But anyway, that's all I had.
We'll
That's
have
all I
you
had to
pick
say.
up that transcript in just a little bit, and
Okay.
it'll sound like a play acting here, but we're going to assign some parts of the play to Don. He'll take the part of the judge. We'll start here on page 5 here, and my assignment will be fairly simple because I'll take the part of John Harvey, and Terrance will take the part of the prosecutor.
Well, thank you for that.
He wasn't real pleased about taking that part because his lips move, so I suppose he could be a prosecutor who can tell fibs. So what this is, it's a
I'm
it's
not going to hang you out to dry, though, John.
okay, very good, thank you. What this is a transcript of what they call a transcript of proceedings. It was held before the Honorable Robert J. Blink. It was in my case, State of Iowa versus a criminal by the name of John Harvey. He's called a criminal defendant in this particular case, and
That's not the John Harvey. It's out in eastern United States, is it?
no, this is not the John R. Harvey who was the chief judge of the Superior Court or of the Supreme Court of the state of Georgia. No.
Oh, okay.
This is John R. Harvey, state of Iowa, and
Des Moines, Iowa, to be exact.
this
The one
case
and only.
this case arose from a disagreement between John Harvey. It really wasn't I didn't even think there was any disagreement because what I was doing is I was on an appropriate mission to do what is called extended media coverage in the courthouse in Polk County when I was shadowed by a fellow by the name of Grayling Ashley, whose lips move constantly. And you can take whatever interpretation you wish from that, but the interpretation I got from after reading the transcript is that this fellow has no concept of truth. And he demonstrated that concept in the courthouse in Judge Novak's case. Now, here is something I think that will be of interest to a lot of families who have come into adverse contact with the court system, and been charged with a simple misdemeanor. There is something in the Fourth Amendment. There is something in the Iowa Rules of Criminal Procedure, and there is something in the Iowa Constitution, and there is something in case law that says you cannot initiate a criminal case against any Iowan without a sworn to a document of complaint. Don, maybe you can show us, because you've got a document there at your right, regarding the Fourth Amendment. I looked that over again just today, and it says that you have to have a sworn to agreement, a sworn to statement before you can. Maybe you can read that. This is called the Fourth Amendment. In this case, it's with some annotation. Don, why don't you go ahead and read that?
The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the particular things to be seized.
Thank you, Don. This says that whenever someone is brought into court, that there has to be a warrant, and that warrant has to be sworn to. In the case of State versus John Harvey, there was no warrant. There was nothing sworn to. There was no document that was even appropriately signed. It said MJ or something like that, and that was supposed to be Grayling Ashley. Now, we had 4 judges. I've had 4 judges on the case altogether. The first 3 judges decided that there was probable cause. Well, probable cause rises, as we found in the Fourth Amendment of the United States Constitution, which apparently is gathering dust and disdain in Iowa, but the probable cause has to be supported with an oath or an affirmation of the party who is making the complaint. There was no oath subscribed to. There was no affirmation subscribed to. There was no signature even. No notary seal. Nobody swore that he was telling the truth, and he probably would have had a difficult time convincing anyone that he was telling the truth until he gets a slick, mealy-mouthed prosecutor who can make anything look truthful with the way he tells tales. Well, anyhow, let's go back to the 4 judges. 3 of those judges determined in my case that there was probable cause. They didn't bother to look at anything. Even when arguments were presented, they couldn't quite get it through their heads that they had to obey the rule of law. The rule of law simply suggests that that they abide by the Fourth Amendment.
Are you sure it's a suggestion?
And, well, it's more than, I say suggestion because to draw sometimes you can understate something and say it more clearly and more powerfully than if you overstate it. And so that's why I say that the Fourth Amendment probably is more than just a suggestion, but it's gathering dust and disdain in Iowa because it is the United States Constitution. Well, the Iowa Constitution also says that in order to put a case before the court, you must have a sworn affidavit of complaint. And in this case, there was none. In fact, we're going to find out that the prosecutor admitted in pretrial discussion that there was no such thing as sworn statements in any of the cases. This is why I want to say something to our families that are viewing. If you have a case like that, in which you are being prepared to go to court, raise the issue of jurisdiction based upon the fact that there has been no compliance with Iowa rules of criminal procedure, because they cannot take you to court unless there's a sworn statement. In fact, I would even ask your attorney, or ask yourself if you're your own attorney, to file nunc pro tunc on any decision that is made in which there is no basis in the Constitution, no basis in the Iowa Rules of Criminal Procedure, no basis in case law to take your case to court, and ask that the findings be reversed, because these prosecutors are getting by with murder when they're murdering the rule of law.
Yeah, and
Well,
I think the common terminology now is a motion to set aside.
motion to set aside
Yeah,
rather than
motion
nunc
to
pro
set-
tunc. Okay.
Motion to set aside, and be real specific. Lack of jurisdiction due to no complaint or the lack of any sort of affidavit or sworn to statement. I think that if indeed what Justin Allen was saying, the assistant prosecutor for the Polk County offices, what he was saying is true, there should be a lot of things that the
He says
prosecuting.
we're in real trouble.
Yeah, because they've been doing this for a long time, supposedly. Well, the Supreme Court in the 2000 case that we cited, State versus Atchinger, explicitly stated that the Iowa Constitution requires, before you detain someone or before you bring anybody on charges or anything like of that nature, and as you were saying also, if they come into your house or do anything like that, as what you were talking about for your families or vocal families, yeah, they have to have something that is under oath, whether it be after the fact that they did it or before the fact. And it's in
Why
the case
after
of
the fact could they get by with that?
well, because they have to use after the fact sworn statements in the case of such as the arrest of John Harvey, because he didn't get arrested until after the. I mean, he got arrested before the actual allegations were laid forth. But either way, the same standard applies. You can't just obviate it because it was after the fact.
Okay, thank you. Let me ask you this question. If a family says, well, we don't have the kind of money that it would take to hire an attorney, thank you for that suggestion about filing a motion to set aside, but we don't have enough money to do that. How would we go about getting the relief we seek when we can't afford the attorney?
Well, that's a question. That's the $1 million question, right? That's the dilemma that most poor folks face. I would say
You can represent yourself.
you can, but to a lot of times it's to your detriment, unless you have very, very, I would say very, very good luck, or you have the backing of the local press or some media that's going to make sure that the judges play honest, play fair. I don't think that your case would have got overturned, John. In all honesty, had it not been for your media outlet here, and it still hasn't been overturned. They're just advocating. The prosecutors are advocating that it's overturned, and I don't even think that would have happened if it wouldn't have been because you had chosen to put this case in the limelight. And I think that shows as a big example of what could happen with publicity. And that's too sad, because they should be that way all the time, not just because it's shined a little bit of light on the situation, but it just goes back to the old attitude that we're just going to do what we want while nobody's watching. And that seems to be the prevalent attitude within the judiciary.
You're absolutely right. Now, what has happened here, I was found guilty by a jury, and I elected to appeal the case. Now, whenever you elect to appeal the case, even though you don't have to pay a high-priced attorney, it still costs like crazy just to get the transcript. Well, I got a partial transcript. I got the transcript upon which the evidence was based, and the information from the only witness for the state, which was Grayling Ashley, and that amounted to several $100s. Now, I also got another transcript of a hearing, and we'll be looking at that hearing in just a moment. What, you got a problem with the mic? Okay. Anyhow, and I thought I had my full transcript over here of the problem, because that had a statement in it that I wanted to put on with respect to what the prosecutor said initially. With, do you have the big transcript? It isn't around anywhere. No, that's all right. We'll catch
Well,
that.
I was there.
You were
I think
there.
I could paraphrase what they were trying to say. What part of the proceeding?
Okay, this was the very beginning. Remember when I first brought the information about this is before the court illegally, and the judge says, "What about that?" As he looked at the prosecutor and said, "Well, if the court holds us fast to that rule, we're in real trouble." And he says, because we don't do it that way. We just simply fill out the papers. And you know, the judge went ahead and, despite the fact that I raised the very best defense, very best sightings of the law, and he said no, they were going to go ahead with the trial anyhow. Despite the fact that it was in violation of Iowa Rules of Criminal Procedure. Don?
I wonder if that is an example of that you have to actually sue these people to get the judge's attention to rule whichever way.
That may be. Well, anyhow, the first one who saw the case and ruled it to have probable cause was Carol Egley, a highly respected local district court judge. But that is not a very highly respected ruling on the part of Carol Egley. And I think that she should come on the air one of these days and say, yes, I looked at that case, and it did not have the proper initiation. It did not. It was not. It didn't have the provision of the sworn affidavit. Well, none of the cases that come before her have the sworn affidavit. So is she really that great a judge if she can pass cases time after time after time, and each of these cases in simple misdemeanors is $250? Well, that builds up a pretty good supply, doesn't it, of funds. Anyhow, it then passed to a newer judge, a judge by the name of William Price. I thought he was a pretty decent lawyer, but Bill Price also looked at this case and refused my motion to dismiss on the basis of a failure to gain jurisdiction. And then it went to Judge Novak, a very articulate judge, a very knowledgeable judge, a very experienced judge, who said no, he couldn't change the decision because it had already been made by a previous judge. Well, sorry about that. All of these issues, I have learned, are issues that must be considered de novo. That is, if it's a brand new idea, you can't base it upon what someone else did before. And so now we have 3 district court judges who together made the same stupid decision, and we have their boss over there asking for more money so that we can continue the kind of structure that we have here. And you had
And
a
who's
comment
the boss, John?
here. Judge Alvarado.
Alvarado.
Okay,
Alvarado?
you had a comment here when I was talking about.
Well, I was going to say that one of the things that they rely on is what's called issue preclusion if it's been decided before. However, when you're raising up specifically, as you had done, the issue of jurisdiction, they can revisit that no matter where you are at in the proceeding. Some of the things you have to wait till appeal to be revisited. However, if you're deciding, like you were doing, jurisdictional issues, they should have been able to reconsider that immediately. It's really horrible that they just kind of sidestepped the whole issue. Another thing that I find really flagrantly out of line was Judge Novak's absolute refusal for you to ask the question of the deputy, did he swear an oath to the affidavit, which was a very legitimate question, because if in fact he didn't, which the document didn't show, then the case would have had to been halted right then and thrown out right then, because that is a critical question. When you have something that does not comport with Article 1, Section 11 of the Constitution, which is the requirement of a sworn affidavit before anyone can basically haul you before court.
Do anything. Okay. We're going to step into the courtroom. Even though we don't have videotape, we're going to read the parts here, and we're going to pretend like that the judge part is taken over by Don Burgmaier. This will be Judge Blink, and that the prosecutor's part will be read by Terrance Walker. So the case came before the court without proper jurisdiction, and I think it's appropriate at this point. By the way, I'll probably do my own part. How's that? To have time in which the court can go through that particular element, because without jurisdiction, the state cannot prevail, notwithstanding a jury verdict. The case was presented before the court in direct violation of the Iowa Rules of Criminal Procedure 2.54, which requires that prosecution for simple misdemeanors be commenced by filing a prescribed and sworn complaint. The complaint doesn't even bear the witness or the signature of the complaining witness, the officer. The Iowa Constitution requires that the changes must be commenced by information under oath in Article 1, Section 11 of the Iowa Constitution, and the framework of the commencement of a simple misdemeanor is conferred by the rules of criminal procedure in the Iowa Constitution. That failure in performance could explain why the county attorney wishes not to explain his position. You see, he didn't bother to file a brief as he was instructed to by the court. He indicated in a prior hearing that none of the cases that he had worked on complies, and if the court held him to compliance, his office would be in real trouble. Well, it is not completely unknown that to the public now that the office of the prosecutors around the state are in real trouble. The facts of the case do not support the conviction of the interference of duties of the officer. No officer's duties were found on the record. No action on the part of the defendant were shown to be interference with the duties of the officer, and the defendant made substantial efforts to preserve each issue and to move for dismissal at each opportunity. Judge Joel Novak made a ruling prior to trial covering much of the defendant's citation of error. Much of the text of that information used to answer the errors is based on facts, not in evidence. And I will give you an example of that right on page 1 of the statement of facts in the case.
I guess the court is supposed to speak up here.
In the ruling on the defendant's motion to dismiss.
Now, that was you, John, reading that, wasn't it?
Correct.
Now, I'm the court. You are referring now to Judge Novak's ruling.
I'm punching up buttons at the same time I'm reading. Correct. And this is on page 1, about midway down, the first paragraph of the statement. The deputy allegedly held that the defendant's harm was in process of escorting him out of the courtroom. That information was not available to the judge, not available to any of in any of the pleadings, and therefore were facts stated that were not in evidence, and therefore, and there are other citations that, upon further reflections, I can give at a later time. But I'm concentrating primarily on the motion for default judgment. I had filed that motion to set aside this case on default judgment because of the inability of the state to state its position. And my plea to the court to dismiss this matter before it goes any farther, when the very basis for bringing it to the court in the first place were erroneous and in violation of the Iowa Constitution, and the basis for the Iowa Rules of Criminal Procedure, and the county attorney has access to the fact that he did not comply with the Iowa Rules of Criminal Procedure. It's a shame that Iowa prosecutors do not believe in the rule of law, and this is a good example where they bypass the rule of law. They do it consistently and then declare that perhaps it was an error, and their office is committing this error time after time. I'm interested primarily in the error that was committed to defend myself from the unjust charge when there is no adherence to the Iowa Rules of Criminal Procedure 2.54. I attempt to follow the rule of law, and it is an unfair game if I'm required to defend myself from someone who does not believe in the rule of law. Much of the text shows that the information used to answer the errors is based on facts, not in evidence. Collusion between the county attorney and the Honorable Judge Novak could have produced the information used to issue the ruling from that hearing, which was held on the 14th day of May 2004. Prosecution of a citizen who is unaware of wrongdoings for wholly passive conduct violates due process, so says United States versus Lane. And it gives the citation for it. Under no circumstances, once the egregious error of the states are called to the attention of the court, should the county prevail, notwithstanding a jury verdict. The case came on illegally and should be halted immediately by the court without further delay, and in the alternative, set the matter for full-scale hearing at another time. Thank you, Your Honor.
Thank you, Mr. Harvey. Mr. Allen, why has the state not filed a meaningful brief in this case?
Well, Your Honor, let me apologize to Mr. Harvey and to the court. At the time that these briefs were being filed, I wholly believed that the record was sufficient to support affirmation of the conviction.
Well, that may well be, Mr. Allen, but the court directed you to file a brief, and a number of legal issues have been raised by Mr. Harvey. They were raised pre-trial. They were specifically addressed by Judge Novak in a thorough ruling, and whether Mr. Harvey agrees with it or not, Mr. Novak undertook to specifically address his specific concerns. He now has addressed these specific concerns on appeal, and the state has not adequately briefed this matter for the court.
Are you referring to the part of the subscribed and complaint? Your Honor, the only thing that confuses me is the concerns of Judge Novak.
My concerns are this, Mr. Allen. You tried the case. The case was appealed. Specific issues were raised on appeal. You have ignored them. And your brief, what you call a brief, Mr. Allen, of July 22nd, is not a brief.
I understand that.
There is no recitation to authority. Now, I understand that you may take the position that this case is so abundantly clear that you do not need to provide any legal authority for the court or advocate on behalf of your client, but the court directed you to file a brief, and you did not. Now, you may not find the issues raised by Mr. Harvey to be meaningful, and in fact, they may not have merit, but this court expected you to advocate on behalf of your client. So I could examine carefully the issues that he raised, and you didn't do that.
I apologize.
You know, that isn't to say that Mr. Harvey is correct, but I certainly believe that when someone raises issues, they should be addressed by the court and the judge. Judge Novak did that before trial. I have a transcript, a partial transcript of proceedings of the trial, and I don't know at whose request this was prepared. Was this prepared at your request, Mr. Harvey?
That's correct, Your Honor.
Okay, so I have a transcript.
I didn't receive a copy of that, Your Honor.
Well, it's been filed with the clerk. You could have certainly ordered a copy if you had wished and been attentive to this matter. There are, as I have read through Mr. Harvey's appeal, and here again I know he referred to a motion for default, and that isn't appropriate. But he has with some length, laid out a number of different assertions. He has carefully, and I must say meticulously and appropriately, referred to portions of the transcript that he believes supports his position, and and what has the state done?
Nothing.
Absolutely. Is it your expectation that the court would do your work for you?
Your Honor, my position, whether erroneous or not, was that the record as submitted and the arguments made by Mr. Harvey. In reversal, the arguments made by Mr. Harvey were sufficiently rebutted by the record as submitted. The record at trial, the court can review Mr. Harvey's brief in the record and come away with a ruling adequate for the state.
So the court could go through the transcript, identify all those specific portions of the transcript that you support your position, research the law, and find the law that supported your position and the portion of the transcript that you think are pertinent.
Well, certainly not, Your Honor. I realize that I definitely took the wrong approach, and I apologize for that.
What have you done, Mr. Allen? You have asked the court to do the work for you.
I understand.
Plus, I would also add, although Mr. Harvey has suggested that this case be decided by this court without oral argument because you didn't file a brief, I am not going to allow that to happen.
Okay, you had a comment at that point, Mr. Allen.
I was going to say
Terrance?
we might want to wrap this up.
Okay.
I thought that it was rather entertaining, by the way.
Okay.
It
Wish I had
wasn't
been
me.
there.
You did a good job.
We
Terrance.
want to thank you for playing the part of a prosecutor. You're certainly not mean enough to do a real good job. But thank you for coming on board. We don't recognize you as a guest anymore, but as a regular correspondent. Now, thank you for appearing on the CPI report. See you next week.